Now, the federal rules of civil procedure and the federal rules of criminal procedure talk about how documents and information must be provided upon request when you conduct discovery. And you should just remember that in different jurisdictions, the flow of discovery is driven in different ways. In some jurisdictions, you don't get discovery until you request it. And once you request it, you get reciprocal discovery. In other jurisdictions, some information must be given automatically to the defense in a criminal case, normally referred to as Section 3 evidence. Anything that was said by the defendant that's a statement that the state intends to rely upon, anything that's inculpatory that the state's going to rely upon, or anything that's exculpatory. There are other things that the state can only hold that the state doesn't have to give until they become relevant at trial. So, for example, I might have evidence that I would use to impeach the credibility of a witness. I don't have to give that to the other side until that impeachment becomes relevant at trial. The argument is I presume that everyone will be truthful, and if they're not, they should not be allowed to know that I have evidence that they're not truthful, because then they might work themselves around it. So discovery has an impact on authentication in that it's sort of the sieve or the strainer through which everything passes before it gets to the other side. And I'll have evidence come into me that I won't give to the other side until discovery requires me to do so. Now, some jurisdictions have open discovery, which is basically you can look at my file anytime you want, and I can look at your file anytime I want, and you'll give me everything. The federal system is not that way, and they're driven specifically by the federal rules of civil procedure and the federal rules of criminal procedure. And I've just given you an example of it here. If you'll look at the federal rules of civil procedure, pretrial conferences, discovery, admissions by parties when admissions are denied, and when admissions were denied and I subsequently prove it, all have an impact on the way in which you conduct authentication. This is sort of like the teeth to properly meeting discovery requirements. When you don't do it and you were supposed to and the other side shows that you were supposed to, guess what happens? You wind up paying their litigation expenses. And you might wind up paying just the litigation expenses for the extra work they did, or you might have to pay the whole freight. And in a big case, we're talking about an awful lot of money potentially, aren't we? So these discovery violations, or this failure to provide proper evidence when it's allowable, can get you into a lot of trouble. And folks don't always think about that when they're thinking about whether or not to disclose a piece of information, and you probably should.